I believe this session is more like a sequel to the previous session which I had done in the month of August, July, August, on the applications which were regularly filed in the trial court. So today we'll be discussing a few basic applications which every person dealing with criminal law, especially on the trial side, should be aware of. So these are the list of topics which we will be covering today. So there are about six miscellaneous applications which we are going to discuss today in today's session, which are filed during the pendency of a criminal trial before a trial court. Either it may be a magistrate court or it may be a sessions court. So these topics, which include provisional release of accused on furnishing cash bail in lieu of surety, permission or no objection for renewal of passport, permission to travel abroad during pendency of trial, summoning of documents during the pendency of trial, return of property which was seized by the police or the investigating agency, and recalling of witness for examination. Now, additionally, I'm also going to cover another app. It is not an application per se, but a document which is regularly filed in 138 matters when the matters are settled. They are called as consent terms. We step by step deal into each topic. Before I proceed, let me just give a disclaimer that there is no standard format for these applications prescribed anywhere. These are derived out of practice. Drafting is like a skill which every lawyer possesses and it differs from person to person. So my draft may not be a standard draft which you may use or some other advocate may use. These applications which we are doing today are regularly filed before a trial court almost on a day-to-day basis. So let us start with the first one, that is provisional release of accused on cash bail. So when an accused person is released on bail, the court imposes a condition that he or she may be directed to furnish surety for his release. Surety is a person who acts like a guarantor, assuring the court that the accused person, upon being released on bail, will attend the court and face the trial. Now, when this condition is imposed, a lot of times the value of the surety is higher, or the circumstances of the accused per se are not in such favorable situation where he is unable to furnish the sureties. So therefore, a provisional release can be done on the basis of depositing cash amounts before the court's registry so as to enable him to come out of the custody. Now, this done like a stopgap arrangement since the surety process may take time and sometimes due to non-availability of immediate sureties. So there are two reasons. First, as I said, that it is for the immediate release of the accused person. And second, to grant additional time to furnish surety before the court. So surety furnishing also takes time. The court has to be satisfied that this person who's standing as surety for this accused is suitable for and can be accepted in the present case. Now, this provisional release of accused on a cash bail is not an ordinary request which is generally allowed. It may be allowed by the concerned trial court or the court granting the bail either by making an oral request at the time of passing of order, which it can be included in the order itself. But in practical scenarios, many courts insist on a written application to be filed for this purpose. Now, when we are discussing about releasing of the accused provisionally on cash bail, there is no specified time period mentioned in any statute or any judgment for this when this application should be entertained. So it is a discretionary power of the trial court or the court granting bail to allow the accused to be released on furnishing provisional cash bail. And this is limited for a certain specific period of time till the time that person does not give appropriate sureties before the court. Now, from my personal experience and observation by sitting in trial courts, this provisional cash bail is allowed from a period of minimum 2 weeks to a period of 8 weeks. Sometimes it may be even more higher depending on the facts and circumstances of the specific case and depending on the discretion of the court. It's a discretionary remedy. It is not mandatory on the court to fulfill it that every case the accused has to be released on cash bail. If the court is satisfied in the interest of justice, this should be allowed, and it is allowed. Now, if the accused is unable to furnish the surety within this specific time period, which is mentioned in the order of release of provisional cash bail, and he or she will have to make a subsequent application seeking extension of this provisional release on cash bail and seeking additional time, like an extension to furnish surety. Now, when this provisional release on cash bail happens, the accused also is required to file an PR bond, that is personal recognition bond, which is sent along with the release memo. It is signed before the jail authorities, which ensures that there's a direction that this accused person will remain present before the court and attend the proceedings. Now, when the process of this cash bail application being allowed, when the person, the relatives, and the advocate for the accused go and deposit the amount in the court's registry or the department, they write if it's a high value and if the notes are of 500 or another, denomination, the department generally asks you to make a list by making a note of the serial numbers of the currency notes, which is submitted, and the department, after counting, issues a receipt which bears reference to the case number, bail order, and that it is deposited in lieu of furnishing surety. That's a provisional for so and so period. Now, this receipt, which is issued by the department, has to be kept in safe custody in original, so that at a later point of time, after furnishing surety, that amount can be refunded back to the accused person. Now, the power to grant this provisional release of accused on cash bail stems from Section 490 of BNSS, which was earlier equivalent to 445 CrPC. The practical point of view, a lot of times the courts ask the advocates to furnish some judgment or a citation or an authority when application of this nature is furnished. I prefer using our own Bombay High Court's judgment in the case of Sajal Kumar Mitra versus State of 2011, authored by Honorable Justice V.M. Kanade. Now, I'll just share my screen to show the sample draft of such application. The title of this remains the same, the cause title of the case. It's a humble application for furnishing cash bail for provisional release of the applicant above named. The applicant was arrested by respondent police station on so and so date in connection with FIR number so and so for offences, and he is named as accused number so and so. If there are multiple accused, this is very much required. Now, the court was pleased to grant bail to the applicant with the surety amount of so and so. The applicant is residing with his family within the city of Mumbai. This is because I have prepared it for Mumbai city. It may be regarding whatever local jurisdiction. And the copy of his or her address proof is attached. There is no question of the applicant absconding. That provisional cash bail may be allowed so as to release him provisionally in custody and furnishing additional time of so and so weeks. So here the concerned advocate has to mention either 6 weeks, 8 weeks, 10 weeks, 12 weeks. But whether to grant that much amount of time is discretion of the court from the date of release of the applicant, so that he can arrange appropriate sureties to comply with the order. That provisional cash bail may be allowed and extension of time of so and so period be granted so as to furnish sureties and any other appropriate release, and it has to be signed by the advocate for the applicant. So this covers the first part of our session today. Now let us proceed with the next topic for today, that is permission or no objection for renewal of passport of the accused during pendency of trial. The Passports Act 1967 has a restrictive covenant which gives the power to the passport authority to refuse issuance of passport or any travel document for visiting any foreign country on the specific ground that the person who's applying for it is alleged to have committed an offense for which trial is pending before a criminal court in India. Now, ordinarily, under Article 21, the every citizen has rights, but this restrictive covenant is put, this strict condition is put so that the accused person does not jump or skip bail. and absconds and flees this India to go to another country. Now there is a workaround to this, that the concerned accused person is allowed to seek permission, a written permission or a no objection, by way of an order from the concerned trial court where that case is pending, the criminal case is pending, allowing the application for renewal of the passport which is about to expire. Now, this is also covered in the government notification GSR of 1993 that specifically mandates the requirement for obtaining an order. Now, the application as such should contain the following essential information: the copy of the bail order, the details of the valid passport which is held by the accused, the date of expiry of the present passport, the period for which it is to be renewed. So it can be to a maximum period of 10 years, but sometimes the court may even at its discretion grant for a lesser amount. However, there are contrary judgments available of the High Courts and the Supreme Court on this aspect. From the practical point of view, my suggestion is that when the accused desires to apply for renewal, he should ideally do it at least 4 to 6 weeks prior to the expiry period, because the entire process takes a lot of time: filing, the say of the prosecution, oral submissions to be made, then it is kept for order. So it takes a quite number of days for this to happen. So it is not an application which is allowed at the instant. It takes 1 or 2 dates or 3 dates at the bare minimum. Now, when it comes to this passport renewal application, I prefer using these few citations while making the application. Either I put it in the draft itself or I tendered these judgments. The most of these judgments are of our own Bombay High Court. The few are cited in journals, and few are the orders which you can obtain from the website. I'll just hold on to the screen so that you can take a screenshot or make a note of the same. So let's just passport renewal application. The name of the applicant, who's the accused, the prosecution, that is who becomes the respondent, the state through whichever police station. Application for renewal of passport. Applicant is citizen of India. Arraigned as accused number so and so offenses, FIR details. Was granted bail. Copy of the bail order is annexed. Where is the applicant presently working? Who all are his dependents? The applicant, because he is arraigned as an accused in the present case, was unable to directly apply to the passport authority for renewal. Therefore, he has approached this court by way of this application for obtaining permission slash no objection for renewal. Now, this is the crucial paragraph which every draft for renewal of passport should contain, that details expressly mentioning about the passport which the accused person is holding. The passport bearing number so and so, there's a unique reference number to each passport which is there on the front or the back side of the passport, which is issued by the government of India, issued at whichever city, Mumbai, Delhi, whichever your local passport office, and the validity period from date of validity activation till the date of expiry, which is in the possession of the applicant. Since this expiry date is nearing within a short period of time, therefore he now desires to renew the same. I prefer putting it directly for a full period, validity period of 10 years. There are the judgments which I said support the full validity renewal of 10 years. Now, most important is to annex the front side and the back side where the details of the applicant are mentioned in the application as an additional exhibit. So, exhibit A was the bail order copy, B is the passport. Now, there is a declaration which the accused gives that he has no intention of evading the law, nor is he flouting any conditions, nor will he misuse the permission given upon granting of no objection for renewal of passport, and that he undertakes to abide by the conditions that may be imposed while allowing the present application. So, if the application is not allowed, there will be irreparable loss and injury which will be caused, as well as monetary loss, because sometimes the accused may require to travel abroad for any business purpose, and if that business could not be conducted, that will directly lead to a link to a monetary loss, and no purpose will be served by detaining him in India. Therefore, balance of convenience is in the favor of the applicant. Now, here the list of judgments which I said, I prefer putting it in the application itself, because a lot of times the trial courts are unaware or are reluctant in granting for full 10 years. Therefore, I list out all the six by citing the references, and at the time of making oral submissions, I tender a copy of the same. Therefore, they pray the this is like a pre-prayer clause where it says that the court may be pleased to grant no objection or a permission for renewal of full validity. And this is your main prayer clause, that this court be pleased to pass appropriate orders or directions granting permission, no objection to the applicant. Write the full name, accused number, so and so herein. The passport bearing number, the identification number, unique identification number of the passport, valid from so and so date to so and so date, standing in his or her name by the government of India for a period of 10 years, and any other reliefs, and the verification clause. So, lot of times in trial courts, in many courts, I have seen that it is directly taken as an interim application on record, but some courts insist that it be filed as a separate miscellaneous application or as a notice case separately. So it differs from court to court. You need to inquire before making such filings before the court about the practice which is followed in the concerned. Now, moving on to the next topic, which we are going to discuss today, is the permission to travel abroad during the pendency of trial. We earlier saw in the previous draft about the renewal of passport. Now we are seeing specific permission to be taken for going abroad, so that the accused may be permitted to travel outside India. Now, right to travel, as I had earlier said, is a part of personal liberty under Article 21 of the Constitution. However, this right is not an unfettered right in rem. It is subject to certain restrictions, especially when that concerned citizen is arraigned as an accused, as named in an FIR in a criminal case, and the case is either pending for investigation or for trial before the court. Inquiry, investigation, or trial at whichever stage. And when this accused person requires to go abroad, he is not automatically allowed to go ahead. He requires a specific written permission from the court, so as to avoid that this person becomes an absconder or a fugitive by going abroad and not facing the trial. Now, this right to travel is not an absolute right. It comes with the rider that only on the basis of discretionary power of the court, which allows by granting the permission in writing, the accused may be permitted to travel. Now, the practical aspect when it comes to making such an application is that this application is to be made to the concerned trial court where the case is still pending. So it may be even at the investigation stage, or may it be after filing of charge sheet, that this case is still pending. However, charge is not framed and the trial is not yet started. So it has to be in the concerned trial court where the case has to be tried by the concerned either a magistrate or a sessions judge. Now, what all information is required to be given in this application? Copy of the bail order, the details of the valid passport held by the accused applicant, and the applicable visa, if any. Sometimes it happens that the accused person may have a long term visa, 2 years, 5 years, 10 years visa, and his passport is also valid. And now, after he's arraigned as an accused in this case, now he requires a permission to travel abroad. So, if that is the case, the passport and the visa copy also has to be annexed. The specific country or the countries which this person, accused person, desires to visit. Now, the most crucial is the period for which this travel permission is to be obtained. Right from departure from India to return back and arrive back in India. It is also better to specifically mention the purpose of the visit, maybe to meet some relatives abroad, or it may be for a business purpose, or it may be for leisure or for traveling or some aspect. But if there is some document available which specifically states that you are directed to attend so and so country abroad, that document is always better to be attached in the application and submitted before the court, so as to ensure that the court is aware that it is not a random permission which is sought and there is specific reason behind such travel. Now, there are a few factors which the courts have to consider while deciding such applications for travel abroad. First is whether there is an extradition treaty with the countries or the country which is sought to be visited by the accused. It is because if the accused attempts to abscond and becomes a fugitive, he has to be extradited and brought back to India. If the India and the country have an existing extradition treaty so as to easily bring him back, so then the court may have a little bit of confidence in allowing such application. Now, possibility of the accused absconding or becoming a fugitive. So the court has to also consider the surrounding circumstances and the facts of the present case, whether this accused person may attempt to flee and abscond or become a fugitive and not face trial. So if the court is inclined and satisfied that he is not going to abscond, then this permission may be granted. The purpose of such visit, whether this visit which he is doing abroad is not contrary to any Indian law. So if you are going abroad to do some illegal activity which is punishable in India, the court will not allow such thing to happen. Fourth is the undertaking which the accused gives in writing that he will return back to India and proceed in the matter. Fifth is if there are any previous permissions given. So the trial may take a lot of time. If there are multiple times permissions granted, and if he has previously followed the conditions which are imposed on the previous travel abroad applications, that also can be considered by the court. Whether the sureties which are furnished by the accused are able to reach that accused person abroad. So this is again a safeguard which is put in so that the court shall ensure that this accused person comes before the court and faces trial. Last but not the least, whether there is any specific reason to keep this accused person in India. Now, this comes from the side of prosecution, whether there is any other criminal case pending in India, whether if traveling, if this accused travels, it will be a threat to the sovereignty of India, whether this accused person is also named as an accused person in other countries and there's a lookout circular or a red corner notice issued. If that is the case, then he may be detained in that country and may not be able to return back to India to face the present trial. So when the court, after considering all these six, seven factors, is satisfied, then the court may grant such permission. Again, this is a permission which is discretionary power of the court whether to grant or not to grant. Now, when it comes to travel abroad application, as a matter of practice, I prefer making a written averment in the application itself. The accused person will furnish a detailed itinerary to the investigation officer or to the court, providing all the information for the proposed travel plan. It may include the passport details, visa details, the hotel or the place at which the accused applicant is staying, the persons whom he is going to meet, the email ID, mobile number of such persons, the places specifically where he wants to visit in that country, what is the purpose of the visit, further any relatives in India who can be contacted, or the details of the surety, the specific dates on which he will be traveling. All these important information can be clubbed together and put it in a detailed itinerary format, in a writing format, and be given to the investigating officer or to the court as it may be directed. Now, when you want to travel abroad, you cannot make a direct blanket permission. No courts will ordinarily allow that. That in the calendar year 2026, the accused desires to travel abroad to USA, China, Canada, Dubai, Sydney, Australia, wherever. So you cannot make a random averment in that way. You cannot have it from 1st January 26 to 31st December 2026. You need to, for each and every instance of travel within that period, you need to make a separate application. It cannot club multiple places unless you are traveling in that same specified few days into multiple cities and countries. Then you need to make a mention of that specifically, but you cannot have a blanket permission. You need to specify the dates, period, and the reason for such travel. Now, from the practical perspective, either this application may be filed separately like a miscellaneous application by giving a separate number, or it may be a regular interim application in the ongoing case, which can be taken and put as an exhibit number. So this practice differs from court to court. It is better to before filing, inquire with the concerned court staff and then accordingly prepare and draft and file. Now, the permission to travel, as I said earlier, is discretionary and only on the satisfaction of the factors which I stated earlier. Then only this permission can be allowed. And this, if it is allowed, a written detailed order is passed. And when the court put some passes an order, it may put some conditions also, restrictive conditions also, as it may deem fit. Sometimes the accused, even despite furnishing surety, may be asked to furnish additional, either a cash surety or a fixed deposit, or keep any other property in lieu of his travel, so that the court can, if required, attach it and recover the amounts from the same. Now, it is another additional tip which I would like to give is that during the period of travel of the accused applicant, the concerned advocate who's appearing in the trial case should remain personally present. This is required so that an exemption application can be filed by stating that he is abroad as per the permission granted by the court, and second is to avoid any unnecessary bailable or a non-bailable warrant be issued because the accused is absent. So when it comes to travel abroad, everybody is aware of the standard landmark judgment of Maneka Gandhi, which is very frequently used when such applications are filed. And a recent case of Parvez Noordin Lokhandwala versus State of Maharashtra, which was decided by the Honorable Supreme Court, this also is tendered and used when such when such applications are filed before the court. So, if required, I'll just pause on for 5 seconds so that you can take a screenshot or make a note of this citation. Now, I'll be showing one draft of the travel abroad application, which is generally filed before the court. I'm assuming this one is direct interim application exhibit number. If required, you may have to name it as a separate miscellaneous application, depending on court to court. The title, cost title, application for seeking permission to travel abroad. The applicant is law-abiding citizen entitled to rights, having permanent address in the cost title and has his roots, belonging to a decent family and no likelihood of him absconding. Then he is arraigned as accused number so and so in the present case, FIR number, police station, offenses. He was arrested on so and so date and granted bail either by this court would imply the trial court itself or by whichever court by order dated so and so. Since the applicant is on bail and is attending hearings, if that is the case that the applicant is frequently attending the court, that gives an added advantage. If the appearance is recorded in the Roznama, it gives an added advantage. Better to attach a copy of the bail order, the present occupation of the applicant, the passport details, and if there is a visa permission already available, then you annex a copy of that also. Now, this is the primary paragraph which is required in the application for travel abroad, that the applicant is seeking permission from the court to travel abroad to this country, and the period of travel from so and so date to so and so date, both days inclusive. Departing date and the arrival date, both are included. The purpose, either it is for business, for meeting a relative, or for leisure, that has to be mentioned. And if you have any documents for the purpose of visit, then please attach a copy of that as an exhibit. Now, this is something which I prefer think that the applicant is willing and ready to furnish details of the concerned person whom he will be meeting abroad. So that if you are unable to be reached, the court can direct that this person can be contacted so that the accused is traced. Now, this paragraph number 8 is optional and only in the case where previous permissions were granted for travel abroad. That from the past records, applicant has traveled abroad and has not flouted any condition. There is no apprehension raised by prosecution that he is flouting any conditions, and there are previous orders also which can be annexed. Now, there are scenarios where you may hold a passport but may not have a visa. So in that case, paragraph 9 can be added that appropriate visa has to be applied in advance. The applicant undertakes, this is the part which I was saying in the presentation, that the applicant undertakes to keep the investigating officer, that is the IO, and this honorable court informed about the exact travel plan by providing the written itinerary mentioning all requisite information. It will also include the flight tickets, travel details, hotel bookings, persons whom he will be meeting, purpose of travel, any other information, contact details, email ID, mobile numbers, etc. Now, this is an undertaking which the applicant gives that he will abide by the conditions imposed upon the application be allowed, and there will be no inconvenience caused by because he will keep his advocate present on all dates of hearing during the period of travel. Then a general prayer, then a general averment which is put that if the application is not allowed, it will cause injury, irreparable loss, and there will be no purpose of detaining him in India. Balance of convenience. The court has jurisdiction to entertain. The primary reason of putting this is because the the power to grant permission is generally vested before the trial court. Craves leave to amend the further forthcoming paragraphs. The prayer clause that please grant permission to the applicant full name to travel to so and so country for the purpose of so and so for a period commencing from so and so date to so and so date. Now, coming to the next documents under section 94 of BNSS, which was equivalent to the previous 91 CrPC. Now, this summoning of documents, power to call for such documents is including digital evidence, is vested in two people, two entities. First, officer in charge of police station and any court, and it can be exercised by issuing written summons to the specific person with the direction to call upon him to produce it before the IO, that is the police officer, or before the court. The reason is this 91 CrPC application, now 94 BNSS, is used in both stages, either at the time of investigation when an FIR is lodged and the police is investigating and require some material documents which are to be included in the charge sheet, or it can be exercised by the court when it is at inquiry stage or at trial stage. Now that we have understood the purpose, the documents which are to be called should be twofold, necessary and desirable. It cannot be that any random documents can be called under by exercising this power. The true test whether this power is used in a fruitful manner is to determine whether it is necessary and or desirable. The stage at which this application can be filed for summoning of documents is at investigation stage. As I said, the concerned officer in charge of police station can do it. Inquiry trial, which the court can do, or any other proceedings under the BNSS or CrPC. The legislative intent behind this provision is to ensure that no cogent material evidence is not placed before the court, so that the true facts are not true facts are actually brought before the court. So this power is used in the correct facts before the court so that adjudication of the case. Now this also reaffirms the right of the accused under Article 21 of free and fair investigation in trial. Because this power is exercised by both the investigating officer as well as the court, it includes both free and fair investigation as well as trial. Now, just a rider to this or a summon is issued calling upon documents by specifically when I speak about the police officer. This is different from the 35(3) BNSS or earlier 41A notice, which the IO used to call the accused person to attend the police station. This is very specific to call upon the person to furnish documents. This is not specific to call the accused person to attend the court, attend the police station. Now that we have understood the background, this application for summoning of documents can be filed by any person, either the accused or the prosecution, that is the state who's de jure complainant, or the victim or the original informant who intervenes into the case. Because there is no statutory bar, any person can file this, or the court may suo moto exercise the power and summon these documents. Now, there cannot be any rowing or fishing inquiry which can be permitted. So, just because a document is required, you cannot go into a detailed inquiry whether this document is having evidentiary value, not having evidentiary value at this juncture. Only purpose of this section is to allow that documents to be summoned and brought before the IO or before the court. Now, this allows production of documents at any stage, but is generally allowed when the accused files it is post framing of charge, that is at the stage of trial. Because there are judgments of the Honorable Supreme Court and our own High Court that it does not allow the accused to furnish the call upon the prosecution or any other agency to furnish the documents which he may use for his defense. He has to face trial, and at the stage of discharge, only and only the materials which are furnished by the prosecution have to be looked into. No additional documents at the behest of the accused can be called at pre-trial stage. Now, there are two or three important landmark cases are of the Supreme Court of India, State of Orissa versus Devendranath Padhi. This very specifically describes at what stage, how the application, and what is the inquiry that the court can do while summoning such documents. It cannot be a detailed mini trial which can be conducted at this juncture. And Nitya Dharmananda case, which specifically raises the point that the accused may not be able to call upon documents before judgment of this Madhya Pradesh High Court in third one, special 22, which explained the rationale behind this 91 application, who can file allowed. So it is a reported judgment of the Madhya Pradesh High Court, which one can read to understand this provision in a much better manner. Now, let me just show you the sample template draft which I have prepared, which I have been using for the matters handled. The title, as such, it is an exhibit in the ongoing case. So, the application, as I said, the application is filed as an exhibit. It's an interim application marked as an exhibit in the ongoing trial case. The title is Application for Seeking Production of Documents under 94 BNSS. You give the explanation of who's the applicant, applicant accused, FIR details. Now, why there is a need to file such an application is because upon detailed scrutiny of the documents filed, along with the charge sheet under 193(3) BNSS, which is earlier 173(2) of CrPC, there are many important pieces of evidence, including various documents, have not been collected by the IO or not submitted by the IO, and the same are necessary and required for the purpose of ensuring true and correct facts of the case are brought before the court. Now, when you say that which documents, you prepare a list. Example, which I have documents, details, articles, and things which can be called by the court by exercising powers under 94 BNSS 91 CRPC. First example is original call data record from so and so mobile company for mobile number so and so belonging either to the accused or to the informant or to any other person, so as to show that there is some cell tower matching. This should have ideally been attached with the charge sheet, but it is missed out. Second, the extract of CCTV footage, which was recorded on so and so date between so and so time, and is recovered and kept in the custody of so and so person. It can be either kept with the IO as a part of the case diary, case file, which is maintained. And when this recovery was done, it was as per Panchnama dated so and so. The Panchnama may be a part of your chart sheet. However, the recording footage, CCTV footage, may not have been produced before the court for whatever reason. Sometimes it happens that there is some letter exchange which is very crucial to the case. Now, that original letter, if it is seized and recovered and kept in the custody of the IO or any other person, that can be summoned and called upon. The original letter dated so and so, written by so and so person in his handwriting, bearing his signature, sent to so and so person. Fourth is certified copy of the agreement which is executed between so and so person registered with the sub-registrar of assurances in the year so and so. Now, this is very specific when it comes to cases involving forgery of documents or involving some tampering to the documents which are made, or where the subject matter revolves around some written form of agreement which is registered with the registering authority. Sometimes, to claim a plea of alibi that the accused person was never present at the spot of incident, he can make an application under 91 to produce the original attendance register or a muster which is kept, or sometimes the electronic record of so and so company situated at so and so address for the period from so and so date, showing the presence of the accused in office. So this is a very crucial document which the IO may skip or may deliberately suppress from attaching in the charge sheet. So this the accused has to bring forward by making an application under 94 BNSS. That is post bringing of charge at the time of trial, desirable for the purpose of fair trial, so as to show non-involvement of the accused and false implication. Now, these, when it comes to original documents, certified copies, the seized, seized materials, when they are in original format or where they can be directly produced for the court, they are directly made admissible in the eyes of the law. The documents are important to prove falsity of the case of the prosecution. This has to be highlighted and shown before the court that if this document is not brought, this will lead to me not being able to make out a defense for myself. That unless these documents will cause severe prejudice to the accused and his right to defend will be affected. Now, if these documents are not summoned and called upon, it will lead to miscarriage of justice because genuine facts are not considered by the court. These documents are vital for adjudicating the present case and goes to the root cause of the matter. And then you make out standard averments, balance of convenience, uh, amendment prayer, and then you come to the main prayer clause that is to issue summons or written direction under 94 BNSS to so and so authority for producing before this court all the documents mentioned in paragraph number 4, where we made out a list. If there are multiple documents, you make out a list in the paragraph and give a reference in the prayer clause and any other case as this court may deem fit. Now, moving on to the next topic, which is return of property. Now, return of property means that some property is seized by the investigating agency, and either at the time of inquiry or trial, it is produced before the court, and the rightful owner is entitled to seek its release from the possession of that police or the investigating agency by taking a permission from the court. Now, there are a lot of items which are generally seized as a part of commission of the offense or as a mode for committing of offenses. So some of which I have listed out, vehi notes which are seized. Nowadays, there is a lot of increase in the monies in the bank account because of cyber frauds. There can be original ornaments, jewelry, gold bars, whatever, valuable items, livestock, including animals. There are, you go on to this subject, you will find a lot of case laws on returning of cattle, whatnot, and even elephants for that matter. There are judgments to that effect from high courts and from the Supreme Court. Sometimes even electronic devices are seized, and you may seek for return of property and assets which are seized and some miscellaneous articles. Now, when this seizure happens, the property is seized by the police or the investigating agency by a written panchnama or a seizure memo. This panchnama or a seizure memo is a document which records that so and so person, generally the investigating officer, has gone to this spot of incident or at this location where this property was found, and what is the description of the property which is to be seized. Color of the property, it may be an item specifically, or the weight, height, the approximate monetary value of that, identification mark if there is any on the property item. And this seizure panchnama or the memo has signature of two punch witnesses who can be later on called as a witness at the time of trial. Now, the permission for return is that court grants interim custody during the pendency of trial of the seized goods by making an application, and such power is exclusively before the trial court. Why I mentioned the word magistrate is because provisions sometimes specifically use the word magistrate. Now, police or any investigating agency, if they seize some property, they cannot by itself destroy, dispose of, or return the property, which either may be a part and parcel of the proceeding or any or maybe linked to it or may not even be linked to it. If it is seized by making a panchnama, then the person who's the bona fide owner has to approach the trial court and seek permission for his release, for its return release. Cannot be done directly by the police at their own level. It's an intervention of the court by passing a written detailed order which is necessary for releasing and returning of such property. Now, when we say return of property during pendency of trial, this is very different from the disposal of the property at the completion of trial, which is under 498 of the BNSS, 452 of the earlier CrPC, which can be done by mode of confiscation, destruction, delivering it to a specified person, or may be dealt with in any other manner as may be directed by the court's order. Now, moving ahead, when we say that who can file such an application, it can be done by the owner, who's the bona fide owner of such property, or a person who's legally permitted to retain the possession of such property. Now, it is not mandatory that the accused is the only one who's the applicant in such case or the victim only. Any aggrieved person, aggrieved as in aggrieved from the seizure of that property, can make an application before the court even if he is a third party because his rights are being affected. Now, return of property is allowed. The court directs the concerned person in whose favor the interim custody is granted to execute a written bond. Now, this written bond is also sometimes called as Supratnama. It's a very landmark judgment of the Supreme Court, Sundarbai Ambalal Desai versus State of Gujarat, which explained the rationale behind the provisions, earlier provisions of CrPC 451 and 457, and how they are distinct from each other. This is something which you should note down. I just hold on to the screen for a bit so that you can note down the citation and read it by yourself. Now, what are the factors that are generally considered by the courts while deciding such return of property applications? Now, whether this property was actually produced before the court or was merely kept in the custody of the police or the investigating agency. If it was actually produced before the court, then an application under 497 BNSS, that is 451 CrPC, be filed. And if it is only seized by the police and kept in its custody and not produced before the, then an application under 503 BNSS, which was earlier 451 457 CrPC, is to be filed. Whether continuing to keep the property in the custody is required at this stage or not. The court has to consider whether this property which is seized has to be continued to remain into the possession of the investigating agency or not. Whether the property, if returned or released in the interim period, will lead to any misuse or used for commission of any further offenses. So sometimes it may happen that some weapon or some other items which are used as a mode for commission of offense is asked to be returned to the bona fide owner. Court also has to consider whether this particular property or that item is going to be used further for commission of any other offense or not. If the court is inclined and is satisfied that this will not be misused, then it may return. Otherwise, it's again a discretionary power. The court may retain application. The most important and the crucial aspect is the locus standi of the applicant, whether the applicant is bona fide owner and legally entitled to the possession of such property. Now, as we saw in the previous slides, there are two distinct classification done under the BNSS and the CrPC for the return of property, which is either produced before the court or not produced before the court. First, let's go to produced before the court under 497 BNSS, earlier 451 CrPC. Now, when property is seized by the police or the investigating agency, amounts to an entrustment of the property to a government agent on behalf of the state, because it is used as a means or the motive for commission of any offense. And the goal is to that the property be returned to its original owner when there is no necessary to retain the custody. Now, this when it comes to the property which is produced before the court, what do you actually mean by the property? The property may be a movable property, or it may be sometimes even an immovable property by way of symbolic possession by producing documents to that effect. Now, property includes any document or any kind of property produced before the court or held in its custody. Now, this property, if it appears to have been used for commission of the offense, or was the reason behind commission of the offense. It can either be an object behind committing the crime, or it can be a mode or a tool used for commission of crime. These both are included in the term of property. When it comes to this specific provision under BNSS 497, there are two, three additions which the legislature has done, which was not there in the earlier 451 CrPC. The subsections 2 to 5 specifically state that when the property is produced before the court, a statement has to be prepared within 14 days of its production, which was not there in the earlier CrPC. Further, it also says that photography and videography of the property must be done. So now when this is documented, a statement is prepared. Along with the statement, there may be photographs and videographs describing the property, explaining how it was seized. And this videograph or photograph can be directly used as evidence in the and after videography and photography, the court should ideally dispose it off by either returning it, or if it is of perishable nature, it has to be disposed of or sold within 30 days from such date. However, this is a provision which is put in. Practicality may differ. These were absent in the earlier CrPC and are only newly added in the new BNSS. Now coming to the second part, which was not produced before the property seized by the police or the investigating agency, but are not produced before the court. So this is done. The application is filed so as to prevent the police from holding it indefinitely, and secondly is to ensure that the bona fide owner gets the property which was seized. Now, this 503 provision explains that when the rightful owner is known, magistrate may give him custody of the property, and when the rightful owner is not known, the magistrate may detain such property uh, and further issue a proclamation asking the owner to appear and make a claim within a period of 6 months from date of issuance of that proclamation. So I am a bona fide owner of this property which is seized by the police and not produced before the court, and I am an identified person who is able to produce documents to show the bona fide ownership of this property. The magistrate, upon being satisfied, will deliver the property to me by passing an appropriate order. Now, when this property is seized, but the actual owner is unable to be identified, the court has to issue a proclamation calling upon the persons to make a claim, the bona fide owner to make a claim within a period of 6 months. Now, when such proclamation is issued and within 6 months, the property which was seized by police and not produced before the court, or when the person who's making such claim is unable to show his bona fide legal ownership, the magistrate can pass an order to dispose of the property by directing the state government to sell it. Now, this provision is in the subsequent section 504 BNSS. Since it is connected to the topic, I have covered this. And further, there is another provision specific to the perishable items which are seized by the police. The magistrate has a power to direct sale of such perishable items when the person entitled to its possession or legal ownership is not known or is absent, and the property is subject to speedy and natural decay, and the magistrate considered as a sale would be in beneficial interest of the owner, or the value of such property is less than 10,000. Now, this is very important because corresponding provision under CrPC 459 only had the value of 500 rupees. This has been increased by the legislature to 10,000 rupees. Now, when such sale of perishable items are seized by the police officer and not produced before the court is done, the proceeds of such sale should be given back to the bona fide owner if at a later stage is found. Now let's see one draft of this application for return of property. Now return of property, again, it can be an interim application in the ongoing trial case as an exhibit number, or sometimes the court may ask you to file a separate miscellaneous application. So this is to clarify from the concerned trial. Now humble application under section blank. Reason why I've put blank is to ensure whether if it is produced in 497 BNSS or if it is not produced in 503 BNSS for return of property. Again, the standard governments, the applicant accuses the bona fide owner and is entitled to possession of such property. You have to describe the property. The ownership document has to be annexed, and this property was seized by the respondent police station in connection with so and so FIR and was taken into custody on so and so date. Copy of the FIR, if any, is attached. And when the property was seized on so and so date, a Panchnama was drawn up by the IO, and the particulars were described in the Panchnama with the signature of two witnesses. If you are having a copy of that Panchnama, better to attach it as an exhibit. Now, there is no dispute regarding the title and ownership of the property. It always vests, if you are having a bona fide title, then it always vests in the applicant. The court can directly presume in your favor because of the document which is annexed. Now, the if the property is not returned back to the applicant, it causes prejudice. And it will prejudice to the applicant and not cause any prejudice to the respondent. The reason for making such application is because this property is no longer needed. Because now in this scenario, the investigation is completed and charge sheet is filed. There will be no fruitful purpose served by holding this property in the custody, as it is not required for any further inquiry or trial. Then again, standard awareness, balance of convenience, and the prayer in this application has to be that the court be pleased to pass appropriate order direction to the respondent, that is the concerned police station, to return the said property. Then you again describe what the property is, it was sealed on so and so date in connection with so and so FIR, and on such terms and conditions as this court may deem fit. Now, moving on to the second last topic for today, which is a recall of for the purpose of examination under 348 BNSS. This provision, when you read the section, you can squarely cover it in three parts. Who can exercise this power of recalling a witness? The answer is any court. When can this be exercised? At any stage of inquiry, trial, or other proceeding. Very clearly make a note that this is a power which is only vested in court and not the investigating officer. Therefore, the term investigation is nowhere used in this section. Now, what power can be exercised? It is threefold. Summon any person as whether if he was not summoned earlier, that this person is present in the court, present before the court on so and so date, though not summoned as a witness. And third is recall and re-examine a person who is already examined. It can be in either one of the three criteria. Now, why such recalling power allowed? Because the evidence of such person appears to be essential for just decision of the case. The primary objective behind this provision is to enable the court to discover the truth and render just decision in order to avoid any failure of justice, miscarriage of on account of omission by a party to bring valuable evidence on record. Power conferred under this section cannot be used by the prosecution to fill up any lacuna in their case because it may cause severe prejudice to the accused and may ultimately result in miscarriage of justice. Now, this power is discretionary in nature and it is not mandatory on the court to allow such application as a matter of rule. When this application is allowed, a detailed order is passed because summoning of any witness has to be done judiciously and not in an arbitrary manner. Let's just quickly go through a draft for recalling of a witness. Now, this cannot be done in a separate miscellaneous application. It is an exhibit interim application in the ongoing trial case. Humble application under 348 BNS, which is equivalent to earlier 311 CrPC for purpose of recalling witness number and name of the witness for further cross-examination. The cross-examination of so-and-so could not be conducted fully in a proper and diligent manner, which has caused prejudice to the accused. The partial cross-examination which was conducted so far was only on a single date, or if it is on a multiple dates, the same is not sufficient to make out the defense of the accused. Some crucial facts, material facts, which would support the story of the accused to make out his defense and disprove the prosecution case have not been brought on record in the partial cross-examination. Now, this failure to cross-examine the witness because the entire set of facts are not brought before the court is not deliberate or intentional, but is inadvertent and negligent in order to, it is not a deliberate intention to recall the witness to fill any lacuna. You have to explain to the court has not got a full and fair opportunity to make out his defense to show that he is not at all guilty of the offense. Because the questions which are to be now put up in the further cross-examination upon this application be allowed are of crucial nature and certain suggestions which are not put earlier for creating a foundation or a base for making out the defense. The applicant has no other opportunity to recall the witness because the case may proceed further, and this provision has ample powers. Now, the reason for this section allowing such powers by any court at any stage to call any person as a witness, whether examined previously or not, is so that the complete evidence or the complete record showing the true and facts of the case are put up before the court, and so that the accused gets a fair and equitable trial, which should not discard the principles of natural justice of not being heard and fundamental and not going against the fundamental tenets of the law. So the witness in this case, if it was identified and previously cross-examined, it will not be difficult for him or her to come back into the witness box and be further cross-examined. So there will be no any unnecessarily prejudice caused to the prosecution if the witness is recalled. Then a little write-up about the powers of 348 PNSS, which was earlier 311 CrPC, that it is like an ultimate resort. Whatever evidence, if it was not been able to brought up before the court earlier, can be allowed if it is very much required for a true and just decision of the case. Then we finally go on to the prayer clause that allow the present application and exercise the powers under 348 BNSS, earlier 311 CrPC, to give directions to the witness so and so to remain personally present before the court on such and such for cross-examination and any other reliefs. Now let's come to the final topic for today, that is consent terms executed between a complainant and an accused in a check dishonor case under 138 of the Negotiable Instruments Act. Now, when a check dishonor case is filed before a magistrate's court, which is the trial court in this aspect, the offense as such is of a quasi criminal nature and it is compoundable. Now, this compounding means it can be settled by amicably settled by the parties because there is a monetary loss which can be compensated back to the complainant, who's the payee in the check, by the drawer of the check, who's the accused. Now, compounding can take place at any stage of the case, whether pending before the trial court or before a revisional or an appellate court. The consent terms is basically a document which makes a detailed note of amicable resolution of the dispute between the parties and recording the terms of the settlement. There is no standard format prescribed anywhere for such consent terms. Nowadays, because of the recent Mediation Act, the courts prefer that such consent terms, if are to be executed by the parties, it is better that it is signed and executed before a mediator. Now, from practical experience, I have seen that the deciding officer, either a magistrate or judge of another corresponding courtroom in the same court premises, is appointed as a mediator, or sometimes the court may even appoint an advocate or a retired judge as a mediator. Now, coming to what is to be included in these consent terms. First, it should have a clear recording of amicable resolution of dispute by both parties mutually. Consent terms, as the word says, consent. The consent is not only of one person, but both parties, complainant as well as accused. So it is done mutually. Now, payment of the total amount of the check which is in dispute, it can be either in full as a lump sum one shot payment, or it can be in installments. A time schedule in a tabular format for such payment. When it comes to installments, then schedule of payments by making columns in a tabular format explaining what date, what amount, and what will be the balance on that day. Balance further for payment in a tabular format is included in the consent terms itself. The mode of payment of such amount, which is due by the accused to the complainant, whether it is by way of a demand draft or online transfer or some other mode. Now, consent terms, the accused defaults in making the payment to the complainant. What will be the consequence? That also is recorded in the consent terms itself. Now, one important clause which is ideally to be put, that no fresh cases to be filed or any pending cases to be continued, which is touching the subject matter of the present complaint for check dishonor upon full payment of the amount due. Second last point being binding nature of these consent terms, that these consent terms are binding on both complainant as well as the accused. And last, that upon full and final payment of the amount under these consent terms, the complaint will be withdrawn. Let's just quickly see a sample draft of the consent terms so that we can finish off the present session. Consent terms agreed between the parties before the learned mediator and executed on so and so date. Now, this gives a background of the case. What was the check number and amount? The parties have voluntarily done so and so so and so is the total amount dash installments on which generally a 15th or a 10th, or says that apart from the total amount, amount as a compensation to the complainant for the litigation suffered during the pendency of the case. Now, consent terms, the total amount and the schedule. As I said, a tabular chart on so and so date, amount of the installment balance. Finally, if the amount gets cleared, then it becomes nil. And if there is any additional compensation which is awarded, and the total amount. So this records on what by what date so and so installment is to be paid. Now, this consent terms has to be accepted by the regular trial court when it is forwarded by the mediator, and it may be taken on record, and from time to time the accused may be permitted to submit screenshots of the payments. Upon receipt of the entire amount, the case will be disposed of as settled, compounded basically. And the consequence of default, in case the more consecutive defaults on the part of the accused, then the case, that is the main case, complaint case will be divided, and the complainant can proceed against the accused in the regular manner. This is a very important clause about not filing any other fresh cases or continuing any pending cases touching the subject matter. This consent terms are binding on both the parties, and it is signed on so and so date. If it is written in English and the parties are not able to understand English, it has to be explained to them. The signature of all parties, complainant, accused, advocate for complaint, is considered in this. So I hope the session was helpful. If there are any questions, you may ask.
Hello, sir.
Yes.
Sir, as you said that while in the traveling procedure, a permission is taken from the magistrate for traveling abroad. So, just I wanted to
Hmm.
make a bifurcation of the cases, like the cases like POC, sorry, LOC. They have a very severe offenses. In that cases, it is must. But like the cases like forgery, theft, such type of FR also needs the permission for traveling purpose abroad.
As long as there is a condition put in your bail order that the accused shall not travel outside India without the permission of court, it is always required that a permission be taken from the concerned trial court. So there is generally, when you read the bail order, one of the condition is that the accused should not travel outside India without the prior permission of the concerned trial court.
Okay. And sir, when the hearings are ongoing, at that time also this condition is carried on?
Yeah, bail conditions continue till the time of disposal of the case, either on acquittal or on conviction. The bail is basically a release that this person will face the trial. So the conditions will continue until and unless the case is disposed of or that condition is modified by the court.
Okay, sir. Sir, I wanted to know about the securities. When the security is filed in the court against the accused person, the security person should be a innocent person. He should not be involved in that case now. Or if the persons who are abetted to that person can be security in the same case.
You mean to say surety? Surety can be any person, whether relative or not. There are judgments to that aspect that even a beggar can stand as a surety to any person. The only criteria is that from practical point of view, if you have stood as surety on your identification document, generally in the state of Maharashtra, they use the ration card. There's a noting made that so and so person has stood as surety for so and so accused person in the case. So if you are already standing as surety in one case, you generally are not permitted to stand as surety in another case.
My question is very specific. Supposing in an accident case, road accident case, if someone is charged with the sections, and is there any if there is no condition mentioned in the bail as to the accused refraining the accused from traveling abroad, then is it mandatory for the person to reveal that, supposing he's working on a merchant navy vessel or something like that, where he needs to go on his job, say every 2 months or 3 months. is it mandatory for him to disclose it before the honorable court, or is it okay that he does not disclose it?
It is mandatory for you to disclose that you are employed in so and so, and you require permission to travel. So at every instance of your travel, you will require a permission from the court.
And if that is not done previously,
Then you
okay,
have flouted the condition of
irrespective
your
of whether
bail.
it
Your bail
is,
can be cancelled because
but irrespective if it is mentioned, not mentioned in the bail, then also it will be cancelled.
no, if the condition is imposed on you not to travel abroad without the prior
Okay,
permission and you travel abroad, which is a direct violation, then your bail can be cancelled by the prosecution by making an
but if no
application.
such, but if no such
But
condition is mentioned, then we can.
in whatever from my practical experiences, 80 to 90% of the cases, such conditions are imposed of not to travel. In
Okay,
very few cases, I have seen that such conditions may not be imposed.
okay, okay,
It's a standard in any bail order. When you read through, you will find one of the condition is not to travel abroad without the prior permission of the court.
okay. Thank you, sir. Thank you.
Thank you, sir. Kunal, one question on the chat box. When court allows the accused to travel abroad,
Okay,
why doesn't the court consider the non-bailable or bailable warrant issued when the advocate is absent?
so this is something which I have
Huh.
already, I actually explained that it's a practical tip which I submitted on my behalf, that it is better to keep the advocate present so that the trial court as a mechanical process should not issue warrants, because a lot of times the court, if it is a separate miscellaneous application allowing you to travel abroad and it is not a part of your main trial case, the judge may not remember that you are granted permission to travel abroad. So therefore it is better to the advocate remains present and files an exemption application before the court mentioning that there's an order to that effect, and therefore he's unable to remain present. Otherwise, in a mechanical process, a lot of trial courts, just because the accused is absent when the time the matter is called out, issue the warrant, and then unnecessarily you have to get it cancelled. So that is what, as a tip which I gave as a recommendation from my side. I
Okay.
hope I'm able to answer to the satisfaction.
Thank you, Kunal, for such a wonderful session. Thanks for sharing your valuable insights. It was such a knowledge packed session. Thank you so much. It was of great help to all of us. Thank you.